let's get into this because this is incredibly important. There was a video done by a medical expert that was really, really, really good. And there was just one little thing that was incorrect. And I want to go into specifically how the rule works. What was stated in the video was basically that those who have an addiction problem, alcohol, drugs, whatever, that they could not go ahead and basically get disability benefits if they had an active addiction issue. And that is not accurate. That is not true. As you guys know, I work with a significant amount of disabled, homeless individuals, disabled, low-income individuals. And of course, in the low-income homeless individual field, there tends to be drug dealers, drug users, things like that. And as a result of that, there's a lot of people who smoke, there's a lot of people who use alcohol. And to be fair, right, the more you get away from the middle class and into the lower earning area or homeless earning area, there are a lot of addiction standards, right? There's vaping, there's cigarettes, and they're spending a lot of money on that, but that's part of that culture. Now, I'm going to tell you what the loophole is for Social Security benefits when it comes to being found disabled while having an addiction. Some people who are cranky and don't love their life will go ahead and be mean in the comments section against me and saying, "Why are you telling people this stuff?" I'm telling you what the rule is. You go figure out however you want to use it. If you're not happy with the rule, you can go ahead and talk to Congress and get it changed. But I'm going to show you what the rule is, how it applies, practical application, all that stuff, and how basically a lot of people get around it. I'm going to show you that as well. All right, let's get right into it. Programs, Operation Manual System POMS, effective date 4/18/2024, DI 90070.050. Again, DI 90070.050. Adjudicating a claim involving drug addiction or alcoholism, DAA, drug addiction, alcoholism, DAA, drug addiction, alcoholism. Cool, here we go. Okay, determining disability in a DAA claim. We do not consider a claimant disabled of drug addiction or alcoholism is a contributing factor material to the determination that the claimant is disabled. Okay, so let me read it again. We do not consider a claimant disabled, right? And so this is like the general sentence that, if you don't know the rest of it, you would think, oh, they got an addiction, they can't be found disabled. Let me read it again. We do not consider a claimant disabled of drug addiction or alcoholism is a contributing factor material to the determination that the claimant is disabled. The material part of this is that there are still people who are addicted who still get found disabled. Here we go. Definition of DAA, drug addiction, and alcohol. Here we go. DAA is a substance use disorder as defined in the Diagnostic and Statistical Manual of Mental Disorders, DSM. Published by the American Psychiatric Association. Exceptions to DAA are nicotine use disorder and caffeine-induced disorder. Number 2, a claimant has a DAA, drug addiction alcoholism problem, when he or she has a medically determinable substance use disorder documented by objective medical evidence from an acceptable medical source. Now, what's in the record that equates to that? You tell them you use pot and you don't have a marijuana card, right? You tell them that within the past 6 months you used, a heavy narcotic, things like that. All of a sudden, real quick, they're going to write down, using and abusing, blah, blah, blah. You just bought yourself a one-way ticket to a medical report that shows that you have a drug condition issue where you're going to have to be adjudicated under this. Number 3, certain substance-induced disorders are included under DAA because they may be long-lasting or permanent. Okay, so they're considered under, drug addiction, alcoholism because they may be long-lasting or permanent. So here's their mini list. Okay, the disorders are substance-induced persistent dementia, substance-induced persisting amnesia disorder, alcohol-induced neurocognitive disorder, inhalant-induced neurocognitive disorder, sedative hypnotic. I forget how to pronounce this. Anxiolytic, you know what? It's too late. It's 3:33 a.m. I'm not even going to try and do it. Induced disorder, anxiolytic, I think is what it is, and hallucinogen persisting perception disorder. I don't know why my brain is just having a tough time. It could be because of the caffeine. Wink, wink. That's funny because of the video we're doing. All right, here we go. Next one. Note, do not make a materiality determination if there is no objective medical evidence from an acceptable medical source documenting the existence of a substance use disorder. All right, so let's talk about that real quick. All right, when it comes to a substance abuse disorder, they want to see at the SSA some jail report, prison report, police report, sheriff's report, doctor's report, specialist report. They want to see a report where it actually exists. Okay. That's what they want to see. Okay. Section C, materiality in the DAA evaluation process. This is like the most important part right here. Okay. Section 1, when to make a DAA, drug addiction and alcoholism, materiality determination. Only make a DAA materiality determination when there's medical evidence in the file from an acceptable medical source that establishes that the claimant has a substance use disorder. They also do this when we call them penal, which is basically like, prison, jail. When that stuff pops up, we also see it for basically like, a report that says like, sheriffs, basically police officer, you get pulled over and you got it in your system while you're driving. They still use those. Okay. It's not just medical evidence. 2, the adjudicator determines the claimant meets our definition of disability considering all impairments, including drugs, addiction, and alcoholism. Again, the adjudicator, the judge, determines the claimant meets our definition of disability considering all impairments, including drugs, drug addiction, and alcoholism. So they're saying, yes, if you're disabled, right, we now need to say, okay, this person's disabled. We need to see if these drugs are material. And if they are material, we're not going to give them benefits. If they're not material, right, we're going to consider giving them benefits. Cool. Here we go. Okay. Note, we do not make a determination regarding materiality if a claimant has a history of DAA that is not relevant to the period under consideration. So if you used drugs back in the day and it's not relevant to what's going on now, so you've used them 2 years ago, right? And your amended alleged onset date is only like 6 months ago. Well, no, let's do a better one. Let's say you used drugs 5 years ago and your amended alleged onset date is 2 years ago. Then it's not relevant, right? The abuse you had on the record then is just not relevant to the current claim going forward. Cool. Number 2, use the sequential evaluation process a second time to make a DAA materiality determination. Apply the sequential evaluation process a second time to determine whether the claimant would continue to meet our definition of disability if they were not using drugs or alcohol. This is the loophole. So if you're like, where do I pay attention? Where do I wake up in this? This is the loophole. They want to ask, and this is the materiality clause situation, would this person still be severely impaired, mentally unsound, physically unsound, blind, if they weren't using and abusing any of these drugs or alcohol or whatever? Would they still be severely impaired? Note, we follow the same rules for evaluating evidence of drug addiction and alcohol claims that we use to follow other types of claims. Cool. DAA is material. We find that drug addiction and alcoholism is material to the determination of disability. Something's biting my leg. I got a bug on my leg. We find that the drug addiction and alcoholism is material to the determination of the disability if the claimant would not meet our definition of disability if they were not using drugs or alcohol. If the drug addiction and alcoholism is material, we find that the claimant is not disabled. So the question is, realistically, at the end of the day, if we took away the drugs and they were still mentally unsound, physically unsound, blind to the severe level required, then you can still be found disabled, even if you have a drug addiction problem. Now, they're going to limit the hell out of your benefits. They're going to require you to have a payee. They're going to do a CDR in a year. Sure, but you can still get benefits. However, the culture is if you get marked down as severe abuse of drugs, right? Severe use, severe this, severe that, severe alcoholism, severe this, severe that. Usually in practical application, the culture of it is that they won't approve you for benefits. But if it comes through with moderate use or mild use of stimulant or whatever, then they'll usually consider the materiality option. Okay. Scenarios when DAA is material. DAA is material in the following situations. The claimant's only severe impairment is a substance use disorder, right? So they're not going to, if your only impairment is a substance use disorder, there's only very small caveats where they'll actually approve you. The claimant's other impairment impairments is not severe by itself. Examples are osteoarthritis, osteoarthritis of the hip with minimal changes on imaging, and an allegation on an anxiety disorder that is not severe. Okay. So basically, like, if your other impairments are in the mild or moderate category and, like, you're taking these drugs and they make you into the severe category, they're not going to prove that. They're not going to. And a lot of people fit into that. A lot of homeless, low income people that are applying for benefits, if they weren't using and abusing these narcotics, their impairments will only be mild or moderate. They wouldn't be severe. And in that instance, boom, they're not getting benefits. C, the claimant's other impairments may be severe, but is not disabling by itself. For example, the claimant may have a back impairment that does not meet or medically equal listing and does not prevent the claimant from performing past relevant work. So what they're saying here is, yeah, the claimant might have a severe impairment, but they could still go back to work. They could still do stuff, and they're not at the severity level of a listing level criteria. Okay. When is drug addiction and alcoholism not material? We find that the DAA, drug addiction and alcoholism, is not material to the disability determination if the claimant would still meet our definition of disability if they were not using drugs or alcohol. If DAA, drug addiction and alcoholism, is not material, we find that the claimant is disabled. And that's the loophole. That's it. That's the loophole right there. The loophole is you can still be found disabled even if you're abusing drugs, even if you're an alcoholic, even if you're lush. If you take those out of the equation, you are still mentally unsound, physically unsound, or blind to the severe requirements of their regulations. Okay. Scenarios when drug addiction and alcoholism is not material, like when you'd be found disabled. DAA is not material when the claimant has a disabling impairment independent of DAA, independent of you using and abusing. The following list provides examples of other disabling impairments that the claimant may have that could be disabling on its own. Okay. A degenerative neurological disease, a hereditary neurological disease, kidney disease that requires chronic dialysis, an intellectual disease, a listing level diagnosis of schizophrenia. The claimant acquired a separate, okay, this is part F. The claimant acquired a separate disabling impairment while using substances. Now, this is interesting because remember, some people will be using and abusing, and that will cause other impairments to come to light or become severe as a result of the use and abuse. Because remember, you use these drugs, you use this alcohol like that, you're going to end up in a bad spot because medically it's going to destroy you. Okay, let's see. Quadriplegic because of an accident while driving under the influence of alcoholism, right? They're going to be quadriplegic whether they were drinking alcohol or not in the future. Just is what it is, right? We're still going to find them disabled. Listing level human immunodeficiency virus from sharing a needle for intravenous drug use, right? They still got HIV, still could become AIDS, still become a problem, right? Although most of the HIV situations, to be fair, like, they don't die essentially, or they don't pass away, from it, they pass away with it, right? The claimant's DAA, drug addiction, alcoholism, medically caused other disabling impairments, but the resulting impairments are irreversible or could not improve to the point of non-disability. Here's some examples. Peripheral neuropathy, permanent encephalopathy. Jesus, sorry. The medical terms right now, and it's 3:42 a.m. It's a little bit tough for my brain. So, and what's happening is this. I don't have my glasses on, which I don't even know where they are because I don't have my glasses on. There they are. They're under the paper. When I don't have these puppies on, if something's not in 16 font, which this isn't like 12 font, maybe 14, I can't actually read it that well. So the problem is, like, my scripts and stuff, they'll be super blown up. They'll be bigger, right? They'll be a bigger font than this. But this, however, it's too small. And then when it comes to a word that my brain can't automatically read, where I have to be like, okay, what are the parts of that medical terminology? And I have to split it up because, medical terms, there's usually like 1 or 2 parts, 3 parts, boop, 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 or 4 parts, and like each part means something to it and your brain has to read it. Okay. Anyways, too much on that. Cirrhosis of the liver, that one's easy. And substance-induced persisting dementia and substance-induced persisting amnesia disorder that develop from long-term alcohol or drug use. You can hear Shadow in the background. He's got the sniffles. All right, now the claimant's burden of proof. This is important because it's like the standard, right? The claimant has the burden of proving disability through the sequential evaluation process. As in all disability determinations and decisions, our burden is limited to producing evidence that work the claimant can do exists in the national economy at step 5, the fifth element of the sequential evaluation process. All right. The claimant continues to have the burden of proving of disability throughout the DAA materiality analysis. Because remember, they make you go through the 5 elements again when you have a drug addiction and alcoholism situation. When we apply the steps of the sequential evaluation a second time to determine whether the claimant would be disabled if he or she were not using drugs or alcohol, documenting the materiality. We must provide sufficient information of determining or decision so that a subsequent reviewer can understand the reasons for the following findings whenever DAA materiality is an issue. So basically, they've got to point to where the records show that there was drugs and alcohol abuse. Then they got to point to why it's material or not material, right? They have to write it out. Okay, so what they say is here are the elements of it. The claimant has a DAA situation, drug addiction and alcohol situation. The claimant is disabled at step 3 or step 5 of the sequential evaluation process, considering all of his or her impairments, right? So we know that they're disabled under the rules and regulations as they are. If the claimant is still disabled at step 3 or 5 of the sequential evaluation process in the absence of the drug addiction and alcoholism, or the finding that the claimant would not be disabled at step 2, 4, or 5 of the sequential evaluation process in the absence of drugs, addiction, and alcoholism. So what they're saying is, look, if we remove the drugs and they're still super duper bad, then they're going to give them benefits. It is what it is. Okay. Note, a single statement by an adjudicator that DAA is or is not material to the determination of disability is not sufficient. However, nobody's going to question it when they say, DAA is not an issue. Like, think about it. Let's say that they write a brief and they put a single sentence in there that DAA, your drug addiction and alcoholism, is not material, right? Nobody's going to question that. Why would they question that? They're just going to let that one slide right through. For documenting materiality, see section or question 14 of DI 90070.041B. Adjudicators must provide explanations in their determinations of decisions or on other appropriate documents, such as residual functional capacity assessment forms. So they're saying, hey, judge, write in some bullet points, some reasons as to why you feel that this drug abuse, that this alcohol abuse is not material. Okay. The 6-step DAA evaluation process. Does the claimant have drug addiction and alcoholism? No, right? No DAA materiality determination is necessary. Or yes, we go to step 2. Step 2. Is the claimant disabled considering all impairments, including drug addiction and alcoholism? Okay. So if we say, okay, the claimant's not disabled. They don't meet a listing. They're all of their impairments combined don't limit their ability to work to the point where they couldn't do a full-time job. Then we say, boop, done. We don't care because they're not disabled to begin with. If they are disabled, we go to step 3. Is DAA the only impairment? Is DAA the only impairment, right? Or is your drug addiction or basically your alcoholism the only thing that makes you severely impaired? If yes, you get a denial because they're not going to approve you if your only problem is you're an abuser, right? Unless there's a few caveats to that, but that's the main thing, right? My only impairment is I really like, this powder, and this powder messes me up, right? That's not it. If the drug addiction or alcoholism is not their only impairment, then you go to step 4. Step 4. Is the other impairment disabling by itself while the claimant is dependent upon or abusing drugs or alcohol? Is the other impairment disabling by itself while the claimant is dependent upon or abusing drug or alcohol? If not, right, if the impairment is made severe only through the use of drugs and alcohol, right, or either one of those, if you get a no, then DAA is material and you get a denial, right? Because that drug alcohol abuse, right, makes your other impairments severe. You were mild or moderate with your severity of your other impairments, but when you use and abuse, you become more severe. If that's the deal, you get a denial. If it's not the deal, then you go to step 5. Step 5. Does the drug addiction and alcoholism cause or affect the claimant's medically determinable impairments? Okay. So does the drug alcoholism affect the claimant's medically determinable impairments? If not, right, then we say DAA is not material. We give an allowance, right? Because if the drug and alcohol abuse is, essentially not causing the effect of the claimant's medically determinable impairments, if it's not part of the equation, then you'll receive an approval, right? And that's where the drug abuse is like mild, moderate, stuff like that. If it is something that's causing or affecting the medically determinable impairments, Yes, but the other impairment is irreversible or could not improve to the point of non-disability. Drug addiction and alcoholism is not material, and we give an allowance. So there's that caveat thing, right? Where let's say you were, drunk driving a car, boom, you get into an accident, now you're quadriplegic. In that instance, right, what happened? I can feel the caffeine's wearing off. I can feel, I don't know if you can tell, but I can feel the caffeine's, it is 3:49 a.m. I feel that caffeine wearing off. The bottom line is that if, okay, you become a quadriplegic, doesn't matter if you were an alcoholic back in the day. You're still a quadriplegic. There's nothing you can do about it. It is what it is. If you were drinking and drinking and drinking, and your liver is now end zone, game done, no mas, right? Class 5, no bueno. Then in that case, same kind of gig, same sort of gig, like cirrhosis situation. Third option, yes. Does the drug addiction, alcohol cause or affect the claimant's medically determinable impairments? If yes, the drug addiction, alcoholism could be material. Then we go to step 6. Would the other impairments improve to the point of non-disability in the absence of the drug addiction or alcoholism addiction? If yes, then you get a denial. So like if you got rid of the drugs and then you would get better, right? And you would, like, even if you had a severe impairment and you were on the drugs and you got rid of the drugs, and then your impairment went from like severe down to, essentially moderate, not disabled. But if you had extreme and it went down to severe, you would then you would be found disabled, right? Because they only require marked or severe. Marked and severe are the equivalent terms in the medical field. So bottom line is, would the other impairments improve to the point of non-disability in the absence of drug addiction or alcoholism? But remember, if you were extreme and then you still become severe, you're still going to be found disabled. So this one's got a little waffle room there. If your impairments would not improve to the point of non-disability in the absence of drug addiction and alcoholism, then basically it's the DIA is not material. You would receive an allowance. You'd be approved. That is the system by which they use to allow individuals who are using and abusing drugs to go on disability benefits. With that said, here's what you need to know. Okay. When people have a drug abuse issue, the main thing that they screw up is that they tell their doctor, and it's not really a screw up. I mean, they should tell their doctor about what's going on, but they tell their doctor about it. Yeah, last time I used and abused, that was 2 months ago. Yeah, I was using it last night. Yeah, this morning I had 6 beers. Whatever. They tell their doctor about it. That's where things get off track. Another thing is they get arrested and it's in their system. Another thing is basically where they go to the hospital. This is the big one, man. When they go to the hospital and it's in their system, it's in the blood test. All of a sudden it pops up. And remember, they have urine analysis, they have a blood analysis, they have a hair analysis. If it pops up on one of those and it's a crisis medical treatment, that's going to be of interest to the judge. Okay, that's what's going to be. And then all of a sudden we're going to get questions like, okay, well, when did you stop using this drug? When did you stop using and abusing alcohol? Blah 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 blah. And that's when these things are really going to start popping up, being problematic. But as a side note, and I know somebody's going to yell at me for putting this in the comments, as a side note, if you don't have recent drug abuse in the record and you're still abusing but nobody knows about it, then there's no way for them to actually know that you're using and abusing because there's no record of it. And what a lot of these individuals do is that, look, if you're using and abusing alcohol, using and abusing drugs, you become a master at the little stories and the little lies that you tell. And you use these to cover up situations that make you look bad. And, by and through this whole process, you end up in a situation where, to be fair, it's a situation where, just to be fair, it's where basically you end up in a bad spot. And when you end up in a bad spot, you're trying to make yourself look better, feel better, whatever your abuse is. And then at the end of it, you can't get out of it because, let's say that you're in a hearing and the judge starts to pinch you. When was the last time that you used and abused, right? Okay, so you start thinking, okay, shit. Because remember, a lot of claimants, they don't have the record ahead of time. So if you're a user and abuser, call your attorney and ask them, what's in my medical record? What's in my vocational record? What's in my, my jail, my prison record as to the last time I used and abused? Because the judge is looking at the same thing, right? And they're like, oh, okay. And what they're going to do is they're going to say, when was the last time that you used and abused? You're like, 6 months ago. And then the judge is like, because this record shows that you told your doctor a month ago that you recently used. Boom, they've got you. Oh, but there's a caveat to that. And the caveat is that sometimes when you basically have a doctor that will copy and paste, they'll just copy and paste into the record, stimulant use disorder moderate, right? Or severe. And they'll just copy and paste and copy and paste. Every time you go in front of them, copy and paste into the record, copy and paste into the record, copy and paste into the record. And there's never, ever a review or pullback on that particular statement. So it just looks like you're continuously and repetitively over and over and over using and abusing. That is a problem you may run into. I hope you guys enjoyed this video. Please remember to go ahead and consider going to Google and basically throwing some review stars up on the board. I always love waking up to those. So if the video helped you in any way, please consider that. Also, very important, please remember to like and subscribe to this video. Now, with that said, if you basically want to ask me a simple question, don't call the law firm from 9 to 5. That's for people who want to apply for disability benefits, who want representation. If you just have a question, call me during the live show on Tuesdays and Thursdays when I go live on YouTube, which is usually later in the day. Also, if you need a full hour, you got a bunch of questions, string questions, trying to figure something out, you have a hearing coming up, you want me to run hearing questions with you, go ahead and I ran out of air there. Go ahead and basically hire me for that hour. Little mini contracts in the bio below, and then I'll put you on my hearing calendar for the hour. We'll get you set up. We'll get you rolling in the right direction. I will catch you guys a little bit later. You have a wonderful, wonderful night, and we will go from there. Thank you so much for this ultra late night. It is 3:55 a.m. We are about to hit 4 a.m., and then we have to wake up early and actually begin working. I will catch you later. Have a wonderful night, and we'll go from there. Thanks so much, and have fun. All right. Bye-bye. Bye-bye.